Hello, I'm Nancy Nawrocki. In this video, I will review what the medical durable power of attorney is and the choices you need to make to create a medical durable power of attorney that meets Michigan law. The medical durable power of attorney is a document which empowers a person you select to make medical decisions for you if you become incapacitated and cannot participate in making medical decisions for yourself. In order for someone to make medical decisions on your behalf, it is important that your wishes and desires are known and communicated to them, and that you trust the person that acts for you to carry them out. There are some serious decisions that you need to make to assure that your wishes will be met. Each spouse of a married couple should go through this process individually, since your decisions may be different than your spouse's. We have prepared this video to explain the requirements of the medical durable power of attorney and to guide you through the decision process. You will be making decisions and creating your medical durable power of attorney based on current circumstances. But, as we all know, circumstances can change over time. So what do you do if the decisions you make today need to change in the future? If you need to make changes, you can come into the office and tell us what the changes are. We will prepare a revised medical durable power of attorney, revoke the previous one, and notify all the interested parties. The power of attorney with the latest date is the one that will be in effect when needed. We have found that providing a little background information on the history of the medical durable power of attorney in Michigan can help people understand why it is the way it is. The medical durable power of attorney as it exists today came about from a 1991 decision by the U.S. Supreme Court. This case, known as the Cruzan case, involved a woman who was severely injured in an auto accident. She was not able to take food naturally. Her parents wanted to remove her stomach tube to withhold food to allow her to die. However, the hospital claimed a superior interest to preserve her life by maintaining the feeding tube. The parents sued to assert their right to make the decision on behalf of their daughter. The case was appealed to the U.S. Supreme Court. The Supreme Court made two important decisions. First, as an American citizen, you have the right to make advanced decisions regarding your health care. And second, food and water are deemed to be medical treatment which can be withheld or withdrawn by choice. But in order to exercise these rights on a person's behalf, there needs to be clear and convincing evidence of the person's wishes. This is a very high standard. The Supreme Court stated that a written document signed by the person in advance would meet this standard. However, anecdotal or hearsay information is not sufficient to meet this standard. So simply speaking your wishes is not sufficient. Your wishes need to be written in a signed document. The state of Michigan has passed laws that implement the U.S. Supreme Court's decision. In the past, a Michigan medical durable power of attorney was valid as soon as it was signed. But this is no longer true. In 2004, Michigan law changed to create a springing medical durable power of attorney. This means that for your medical durable power of attorney to be in effect, two physicians or a physician and a licensed psychologist have to agree that you are not able to participate in medical treatment decisions, and they need to document this agreement by signing a form called Determination of Inability to Participate. This determination can be temporary, such as for someone who is under anesthesia during a medical procedure, or permanent. If the determination is temporary, the physicians will specify a date and time that the power is no longer valid. So a medical power of attorney may or may not be enforced depending on your ability to participate in your medical decisions. Also, Michigan law has changed to include the concept of substituted judgment. Substituted judgment means that your agent can deviate from the instructions in your medical durable power of attorney if, based on conversations that the agent has had with you, the agent believes that you would have made a different decision in light of the current circumstances presented to him or her. So moving on, after you view this video, the first thing you should do is to work through the Consumer's Toolkit for Healthcare Advanced Planning. This toolkit is available from our office or can be downloaded from the American Bar Association website. To find it, Google Consumer's Toolkit for Healthcare Advanced Planning. This toolkit will help guide you through the process of deciding your wishes, making your decisions, and communicating those decisions to your loved ones. It is very important to have meaningful discussions with your family, your agents, and perhaps your doctor about your medical decisions. These discussions may help you clarify your own wishes and will help assure that the people who may be involved in your medical decisions understand your wishes. The Consumer's Toolkit has some tools that can help you with this. To assist our clients, we have created a Medical Power of Attorney worksheet. This worksheet documents your decisions so that the person preparing your medical durable power of attorney can be sure it exactly reflects your wishes. You can obtain a copy of our medical durable power of attorney worksheet by contacting our office. One of the most important choices you will make in this process is the choice of your agent and successor agent. Your successor agent will act on your behalf in the event that your agent is not able or willing to do so. The people you choose for these roles will be acting for you when you can no longer act for yourself. The people you choose should be people you trust to carry out your wishes, even if they may personally disagree with them, and they need to be strong enough to follow through with your wishes even when family, relatives, doctors, and others pressure them to do something different. You can select practically any adult as an agent except for your healthcare provider. Quite often people select their spouse or child, but you can select someone else, a friend, a sibling, a relative, or someone unrelated to you. In choosing your agent and successor agent, choose people you trust who will best carry out your wishes. The Consumer's Toolkit has a tool that can help you think through the selection of your agent and successor agent. It also has a guide for healthcare proxies. Proxy is another term for an agent, which explains their responsibilities. It can be helpful if you give copies of this guide to your agent and successor agent. The second important decision is one you must make, as required by law, about whether or not you want to give your agent the ability to withhold or withdraw the artificial delivery of food or water as a life-sustaining treatment. Michigan law requires that you choose only one out of your 4 options regarding your wishes for life-sustaining treatment. The first option directs your agent to withhold or withdraw treatment in the event that your attending physician determines that you have an incurable condition that will result in death in a short time, or if you are in a coma or persistent vegetative state which is irreversible. The second option directs your agent to withhold or withdraw treatment under any circumstance that will only postpone death or prolong an irreversible coma. This option is different from the first option in that the determination of the physician is eliminated. The third option directs your agent to provide maximum treatment to prolong your life as long as possible. The fourth option allows you to provide a directive in your own words. Some religions have language which meets Michigan law, which their members choose to use. Again, Michigan law requires that you must choose one and only one of these 4 options. Next, there are 3 options which may or may not be included at your discretion. None of these are required by law. You may choose one or more of these options, or you may choose none of them. The first of these options directs your agent to request aid in dying and allows you to specify limits on the powers your agent has in this regard. If you select this option, you should be aware of the legal implications of this selection. In 2007, the United States Supreme Court declared that aid in dying laws are constitutional. In response to this decision, Michigan amended the state constitution forbidding aid in dying, making it a crime for anyone to assist someone who requests aid in dying in Michigan. As an American citizen, you can travel to any of the states which currently allow aid in dying per the Supreme Court decision. These states are presently Oregon, California, Washington State, New Hampshire, Montana, and potentially New Mexico. If you choose this option and decide to limit your agent's powers, you will need to write out what those limits are. The second option directs your agent to donate your organs for transplant. The third option directs your agent to allow you to die at home if in his or her judgment this is the best option for your care. Your medical durable power of attorney choices are very important, and you need to give them careful consideration. Thank you for your attention. We hope this video is giving you the information you need to help you through this important process.